Welcome to today's presentation. I forgot it is in English language. So it is Decentralization amid Centralized Regulation. That is Markets and Crypto Assets Regulation. My name is Karla Krmpotić and I'm a Senior Legal Associate at Hrdalo Krnic Law Firm. So today's scope of work I will give you a brief introduction regarding markets and crypto assets regulation. I presume most of you have an overall knowledge what it means. Then we will dig into certain aspects of markets and crypto assets. That is the exclusions of an object of markets and crypto assets. Then we will touch upon staking, stablecoins, and finally, regarding the influencers. What influencers has to do with markets and crypto assets regulation at all? So to start, markets and crypto assets regulation is a landmark regulation that provides us with the provisions regarding the crypto assets market, and it's really a fundamental piece of legislation, and it is centralized in a way that it applies throughout the whole European Union territory, and is implemented directly because it is a regulation. It applies to natural and legal persons or other undertakings that issues tokens, offer them to public, seek admission to trading, or that provide crypto asset services. To certain institutions and corporate entities, it does not apply to, but they are regulated with other set of legislation for now. What is out of scope of MiCA? This is a very heavy slide. What is out of scope of MiCA? We will not dig deep into each and every little thing which is out of scope. We will focus today on the decentralized finance and what it means that it is out of scope of MiCA. So, clicker. Yeah, the only thing where it's mentioned anything regarding the decentralized finance is in the recital part of MiCA. Recital part, I would like to enhance that this is not law. Recital just shows us the intent and the spirit in which the law is presented to the public and the spirit in which it was written, but nevertheless, recital provisions often are buried deep down into the regulation, not directly. So the recital 22 of MiCA states that where crypto asset services are provided in a fully decentralized manner, without any intermediary, they should not fall within the scope of this regulation. What does this mean? We still don't know. Because Markets and Crypto Assets was published last year, and it is a piece of regulation. Okay, but you also have layer 2 regulations. Layer 2 meaning the regulatory technical standards that explains certain parts and certain articles, explains the implementation part and the technical aspects. So when you combine layer 1, which is MiCA, and layer 2 regulation, you have 1,000+ pages of regulation. So it's a lot of text. As a practitioners, we waited for the European Union institutions to issue those consultation papers to maybe provide us with the answer of what it means to be fully decentralized. But in the first consultation paper, ESMA stated that the exact scope of this exemption remains uncertain. ESMA also considers that an assessment of each system should be made on a case-by-case basis. That basically means they don't know, they still don't know, and that assessment of each DeFi or decentralized system should be done on a case-by-case basis depending on their functions and structures of the same system. Also, in the one other consultation paper regarding the conflict of interest, ESMA stated that even where crypto platforms pose as a DeFi in its sense, it is far from certain whether they are, in fact, fully decentralized. In MiCA's sense, some type of legal entity is often related to fully decentralized platforms. What this means, if something poses as a DeFi platform, if a DeFi platform calls themselves, we are a DeFi platform, that doesn't mean they are in fact fully decentralized in the meaning of MiCA, and therefore out of scope of this regulation. Also, they stated, some type of legal entity is often related to fully decentralized. That means you have a certain point of control, and they call it a legal entity, in each of those systems and platforms. We will dig into this, what it means to be a legal entity in this sense. So before clicker, yeah. So before we dig into the certain provisions that indirectly means that are applicable to the DeFi, let's think of a broader view of the decentralization. That means the technical and organizational and governance view. You have to think of the absence of any intermediary. If the DeFi system doesn't have any central... It doesn't listen to me. Come on. Okay. If it is in absence of any central server, organization, or authority exercising any control, that means that certain participants can have great decision-making power, and then you have to decide if it is a great decision power or not. Then you have to look at the project's architecture, at the on-chain components and on the off-chain components. Maybe off-chain components often can be seen as centralized. What it means if you have blockchain bridges, or if you have oracles which are provided locally from a specific participants of the project, and therefore sharing the information from the off-chain to on-chain, maybe they can be seen as a limitation of decentralization. Then you have also management, organization, and control of a protocol. What I mentioned earlier, so if you have, for example, wallets that are multi-signature wallets, who has the control of these wallets? Who has the control of the custody of the assets of the customers? Who holds the private keys? They're all questions that must be imposed when assessing if you are a decentralized protocol or not. Also, who controls the online interfaces? If the online interface can restrict users from access to that interface, does it mean that it has some kind of centralization? Probably yes. After online interfaces, you have also existence of payments or royalties allocated to the creators, owners, or operators. Do they collect any type of fee? Do they collect any type of fee? And is the software maybe provided on a commercial basis? And that's why the software is provided as a service. So this was an overall questions we have to ask ourselves, what it is to be fully decentralized. But we can also do a little legal digging in the MiCA provisions. So, crypto asset service provider. The definition of CASP is a legal person or other undertaking whose occupation is to deliver services, etc. What is important is a legal person or other undertaking. What that means, what is other undertaking? We don't have the definition in MiCA per se, what it means to be other undertaking, so we have to see at the court case law of the European Court of Justice. And the ECJ, in numerous rulings, summarize this as a person or legal entity engaged in economic activities with or without profit intentions, but if it competes with those of profit-driven operators. Also, It can be several legally independent undertakings acting as one party, or just one party by himself. So the point of this and the base of this, that all links between particular parties matter. So it can be organizational, it can be economical, it can be legal, structural. So everything has to be built in one picture and painted as one picture. What first came to my mind are DAOs, decentralized autonomous organization, can be seen as another undertaking. While digging into the layer 2 regulations, I think this was a final draft of the second consultation paper that stated that decentralized applications are set up smart contracts which do not need to be operated by a clearly identifiable corporate entity. So you don't have to have an incorporated entity. And furthermore, they stated they can be organized as DAOs. So if you are a DAO, it doesn't mean automatically that you are decentralized. Okay, further digging can be done through a definition of distributed ledger technology. DLT means technology that enables the operation and use of decentralized ledgers. This doesn't tell us much, firstly, and that doesn't differentiate for permissionless from permissioned distributed ledgers. Permissioned are often centralized, but permissionless distributed ledger systems, in one other consultation paper, ESMA stated that it is DLT in which no entity controls the distributed ledger, and DLT network nodes can be set up by any person if there is technological means for it. Conclusion of this is, if a protocol runs on a permissionless DLT, is not under control of a single entity, so you don't have that central point, and no single entity governs its usage or provides indispensable core services, that means you could be fully decentralized. This is all, again, I'm stating in theory. ESMA should, before I show you this, ESMA should present, European Commission should present a report to the Parliament and to the Council by the end of this year on what it means to be fully decentralized. And that will be important for the decentralized protocols to see and to assess and to be on the forefront to see whether they have to comply with MiCA or not. In the European Union, there was no much talk regarding this specifically, but we have the Danish Financial Supervisory Authority who provided us with the kind of a formula, and it covers basically a little bit of everything we talked about today regarding this. So if you want to know more, you can check their formulas for assessment. And next, we have staking. Staking is locking of crypto assets to earn some rewards. Okay, so firstly, when we read MiCA, staking was out of scope of MiCA. But then ESMA presented us with the answers regarding staking and differentiated direct staking and staking as a service. If you do a direct staking, what that means? Locking crypto assets in order to become a validator to earn some block rewards for creating new blocks. That is direct staking. It doesn't have to be you doesn't have to be licensed. It is not prohibited, and it is not regulated by MiCA. It's business as usual, such as staking at the Ethereum 2.0. Okay, but what they stated, which was interesting, that they said that staking as a service should be compliant with MiCA. What that means, if you have some kind of a platform that stakes clients' assets on their behalf, they are seen as a CASP that provide custody. Therefore, has to be licensed as a custody service provider. And therefore, all of the MiCA principles regarding crypto asset service providers apply in this sense. That was staking. We have a lot of topics today to go through. Next topic I would like to touch upon with you is stablecoins. So we have today here with us Vice President of Circle for Europe, Ms. Sanja Kohn, and I thought it would be convenient to mention the first crypto asset white papers issued in the 30th of June of this year, which means they are fully regulated. It is connected with the USDC and EURC. Okay, but firstly, let's give us definition of an electronic money token. Electronic money token, that is stablecoin, means a type of crypto assets that purports to maintain a stable value by referencing the value of one official currency. One official currency. I would, here, let's do the clicker. Yeah. So in order to be fully compliant EMT money issuer, electronic money token issuer, you have to be credit institution or electronic money institution, licensed as such. You have to brought up a white paper, you have to notify it to the competent authority, and also you have to publish it. And also there are other requirements you have to fulfill. But I would like to state few premises and few conclusions regarding electronic money tokens. So, electronic money tokens are in the scope of MiCA if they are offered to the public in the European Union, if you're seeking admission to trading, and if you are the issuer who is credit institution EMI. But what I would like to say, if you're referencing an official currency of the European Union, it is considered to be offered to the public. So it is by automatic European Union claims jurisdiction if it is an official currency. So, conclusions from this, if it is referenced in euro, deemed to be offered in the European Union, it is in scope of MiCA. If it is not referenced in official currency, but is offered to the public, is seek admission to trading, is also in the scope of MiCA, such as if it is referenced in US dollar. Also, if it is not referencing official currency, it is not offered to the public, and you don't seek admission to trading, it's just business as usual, and it is out of scope of MiCA. So, these are the examples of the regulated stablecoins as of today. These ones are fully regulated because they notified and published white paper. But what I tried to find for Monerium, I didn't find that they published and notified their white paper. That means they're not fully compliant because you have to have both things. EMI license, and you have to have a white paper that is notified and also published. But a logical question imposes, what happens if the stablecoin is not regulated? It can have impact on customers, on issuers, and also certain impact on CASPs, which I will not touch upon today. But the impact of customers, that means that all of the safeguards and consumer protection safeguards from MiCA does not apply, such as redemption rights, such as reserve of assets rights, such as all of the preconditions that MiCA imposes does not apply. It also can have impact on issuers. Authorities can issue sanctions, fines. Also, they have temporary intervention powers, which means if a financial system of the European Union is under threat, or there is a threat for markets in crypto assets as a whole, they can intervene. But to conclude this slide, European Union didn't issue any sanctions or fines or whatsoever up until this point. But I think it's because none of the layer 2 regulations are also finalized, and they are assessing the situation for this year. But we will see, probably from the beginning of next year, when MiCA comes fully into force, what will happen with the stablecoins that are not regulated. And we come to the favorite part of my favorite part of today's presentation. That are influencers in MiCA and what they have to do with this regulation. So it has to do with the term that is called reverse solicitation. What that means? That is a provision of crypto asset services from not authorized CAS under MiCA by the CAS from a third country service at the exclusive initiative of the client. What that means? If I, as a Croatian citizen, ask from a US-based protocol from them to provide me with some type of crypto asset or with some kind of crypto asset service, they can offer me that. But if they solicit me in reverse, it is strictly prohibited. So, solicitation of EU clients, regardless of means of communication used for solicitation, promotion, advertising of third country firms, such as the one from the US, is strictly prohibited. You have to be MiCA compliant or not and registered as a CAS, or otherwise you cannot provide those services. ESMA also issued the Layer 2 guidelines regarding this, and what it showed us is an interesting point. So, examples of solicitation can be from that US company, internet commercials, brochures and printed materials, telephone calls, face-to-face meetings, social media platforms, and mobile applications. This can be very detrimental because we know all of the marketing operations today in this ecosystem is provided through online services and through social media platforms. Also, if that same US company came to today's conference, let's say, to the Web3 Tales, they could be seen as soliciting clients in the European Union. Why? Because it said participation in roadshows, trade fairs, and events. And this all could be construed very broadly. So any means of marketing or promotion. And that's where we came to our influencers or finfluencers. Solicitation from that US company can be conducted by that US company itself or by any other person acting explicitly or implicitly on behalf of the firm. ESMA presented influencers as an example, and influencers can solicit customers by, for example, directing the audience to the third country's firm's website, providing means of access to the service, displaying the firm's logo, offering promotional deals. All the things we know they're done today could be seen as soliciting clients. But what is the liability of the influencers? For now, there is no liability for influencers, just for the third country service provider. But the SMSG, or ESMA Securities and Market Stakeholders Group, in the latest paper, advocates for regulating the marketing activities of those influencers as financial advisors. That means that all of the Twitter influencers and all of the other social media platforms influencers could be seen as financial advisors, and then specific regulations would apply to them. This is of course not yet in force, and it is questioned, will it be in force? But it is interesting to see from that viewpoint. Also, one example for the same solicitation of clients is if you have an online interface that is translated to a certain language, official language from the European Union. So, if a Serbian company has a website that has Croatian translation, that can mean that they are soliciting Croatian companies. And few of other examples. Even if it is on the exclusive initiative of the client, even if I ask for the US company to provide me with services, they can provide me with that exact service and cannot market other services. So, and they can offer me that service, but just for a short period of time. Yeah, and by this, I am concluding my presentation. So these are links on the consultation papers that I just mentioned. And as a small conclusion is regulation is often reactive, not proactive. But maybe as a decentralized protocol, you can act proactively and assess your current state, because then you will be at the forefront of the regulation and of the being compliant. And that's all for today from me. Thank you. Yeah. Anyone has any questions? Yeah. 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 In the EU. EU. Yeah. Mm-hmm. Yeah. Yeah. Yeah, and on the in the inter-country relations, okay, on the territory of the European Union, there are certain mechanisms to sanction players, but if the jurisdiction of EU is claimed, then EU can impose sanctions on other countries as well, such as the UK company. And if, for example, if Binance came here and is not a CASP, officially regulated as a CASP, that can also mean the end of the presentation, that it can be solicitation to EU clients. And then what would be the repercussions? For example, they can be put on the register of non-compliant entities in the European Union. That is an exact wording, so they can be put in the non-compliant registry. But again, is that a sanction? That is that status sanction, which will probably affect negatively their corporate relations and the signing of contracts and AML checks. But is it really a sanction? Yeah. Thank you. Yeah. 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 That means you understood. Thank you very much, everyone, for listening to me. And have a great conference, the rest of the conference.